Court Watch with Alex Swoyer, and I'm launching the first episode of my podcast today as the Supreme Court gavels into session next week after its summer recess for the 2022 term. For any of you not familiar with how the High Court's schedule works, the justices launch every term the first week of October, and usually they wrap up by issuing all their opinions before July. Today, I'll highlight their major cases coming up in the next few weeks and also chat with Carrie Severino, who is president of the Judicial Crisis Network. Her organization has been supportive of President Trump's judicial nominees, from federal district court appointments all the way up to the Supreme Court. Carrie has insight into the workings of the High Court, having clerked for Supreme Court Justice Clarence Thomas in the past. Hey, Carrie, thanks so much. I appreciate you taking time to join me for this first episode. I'm very excited to get this started. And I'm also anxious, as I know a lot of our readers are, to find out exactly what cases, at least so far that we know of, that you're paying special attention to this term.
Yeah, it's great talking to you too, Alex. This is going to be another exciting term. Obviously, nothing really competes with last term for the number of super high-profile cases, but there already are some cases the Supreme Court has agreed to take that are going to be really significant. And of course, they're taking more cases all the time. They'll be sitting at the end of September to accept a bunch more cases. All of the petitions that built up over the summer, they'll decide at the end of September. So we're going to get more. For right now, I see really big cases in the religious freedom front, some big cases dealing with election law, and then with racial discrimination in education. So the religious freedom front, we have 303 Creative, which is a case, if you remember the Masterpiece Cake Shop case about whether baker Jack Phillips could be forced to make wedding cakes celebrating marriages that he had a religious objection to. This is kind of the same thing, but for website design. So it's a woman who has a website design company, wants to be able to do wedding websites, but doesn't want to be promoting marriages that are going to violate her own religion. And the same Colorado commission that said that Jack Phillips had to bake this cake and the Supreme Court had to reverse is saying she has to make websites, which is, I think, if anything, even more clearly expressive content, advancing positions that she disagrees with. So that's going to be a really important religious freedom case.
Yeah, I guess also it could be religious freedom, but also, I guess, free speech too, right?
It's just First Amendment, right?
Yeah, and so I guess a quick follow-up, I think that there's also an Oregon baker, right, who has run into the same type of conflict as Jack Phillips, and I believe has petitioned the Supreme Court to hear her case. And so I'm curious, do you think that given that we have 303 Creative being heard, that could impact, like the Oregon bakers cert petition?
Absolutely. I think this is what we're seeing is this is not an issue that's just going away. I think that's going to be one of the lessons for the court. Sometimes they try to just let's just decide this case narrowly to get rid of this one case before us. But guys, you can't avoid just addressing and grappling with some of these really hard questions of when religious freedom intersects with LGBT issues, and how do you navigate that? You're not going to get away from it. It's just going to keep coming back.
So, if
they just need to decide it in a clear way, so that it can, the other courts, like in Oregon, like everywhere else, can address it, whether it's bakers or photographers or web designers, et cetera.
Right. Because I know Masterpiece was pretty narrow. So I guess if there had been more of a direct ruling, it maybe the 303 Creative case wouldn't be before the court.
Yes, exactly. But remember, Masterpiece Cake Shop was decided back when Justice Kennedy was on the court,
right?
And he was the fifth vote there. So I think we're going to, just from that change alone, I think the court is going to be willing to grapple with kind of the question more broadly, rather than try to just having to find the nearest possible ground you could actually get five people to agree on anything of. And I think that'll hopefully make this. That plus the recognition that, hey, we've tried doing it the narrow way, it's not working. So we need to just have a clearer guideline set so people know that their First Amendment rights are being protected here.
Okay, right. And then I think you also mentioned the affirmative action cases too that you're keeping an eye on.
Right. Yeah. So these are two cases coming out of both University of North Carolina and Harvard. And so it's kind of nice because it covers both areas here. UNC is governed by, obviously, a public university. It's governed by a federal law that it says in the 14th Amendment that you have equal protection of the laws, right? And Harvard, while it's not a public university, receives huge numbers of public funds, as does almost every university in the country. And so for either of them to be discriminating on the basis of race in their admissions would violate that law. And so the question, and this is something that kind of on the theme we were just talking about, the court has addressed this issue before, but it hasn't done so in a super clear way. And it's done so in a way where it most recently it said, well, okay, it's not really in the spirit of the 14th Amendment to let universities look at race in admissions. We'll let them do it for a while, but maybe in 25 years, we won't need to do that. That was a case that came down in 2003. So those 25 years are almost up. Apart from how strange it is to say that there's a constitutional principle that has an expiration date on it, there's also just the fact of the matter of the court, this current court, because they are originalists, because they believe in interpreting the Constitution as it's actually written, as the text says, I think they're going to have a lot harder time saying, hey, wait a minute, how is it, just because you're saying you're well-intentioned in the way you're discriminating on the basis of race doesn't make it any less discrimination on the basis of race. And at the end of the day, there are people who are being harmed in these cases. In particular, it's Asian American students who are being, for whom it is much more difficult to get admitted into either of those schools, even if they have the same, grades and the same activities
right.
and the same everything else, you're just that much less likely. And it's just hard to get away from the fact that it's because of their race that they're being discriminated against. And so I think that's going to be an interesting one to see the court revisit the issue, but now with a originalist majority.
Well, and also I find it interesting with Justice Jackson being new to the court this term, and I believe she's recused in the Harvard case, but not the UNC one, right? So, is there any significance there?
Yeah, I think that's going to be interesting. She was not serving on the board of, I don't know if it was a board of visitors, board of directors of Harvard during some of the period where this discrimination is happening. So I'm glad that she agreed to recuse herself from that case. It is kind of funny because it's basically the same questions coming up in the UNC case, but she presumably will be sitting on that case. And that's pretty typical practice at the Supreme Court if you don't have a direct
conflict,
a direct personal conflict. You can sit on it even if it does address some of the same issues. So, but obviously she's likely to have a strong and well thought out opinion because she's not only someone who's obviously worked in the law for a long time, but also has been involved at the university governance level.
Mm-hmm. Right. I mean, it's going to be, that's, I think, the one everyone asks me about as a Supreme Court reporter. Everyone's asking about affirmative action. I did do an interview with the plaintiff in the case, and he had mentioned that he would like to see the court even go further beyond what we're talking about, college applications, right? Like job applications, the idea that you have to check this race box on contracts and stuff. I don't know. How far do you think the court will go beyond that, or do you think they'll probably stick to the college application context?
Well, I suspect the immediate implications will obviously be, because they're going to be interpreting language that specifically statutorily applies to universities. However, obviously the implications of what they're saying apply in a more broad way in government contracting, in government employment. And as the Harvard case shows us, it's not just if you're working for the government or government entity. It's also if you're a private institution that's receiving government funds, that often can trigger these non-discrimination provisions as well. So I do think it's going to have implications, if only because people will recognize, hey, if we're doing it in this other area, this court isn't going to be sympathetic to the idea that we're going to turn a blind eye to certain types of racism.
Mm-hmm. Now, okay, I want to also touch on, you mentioned a couple other cases. I know the first Tuesday, there's two redistricting cases that everyone's kind of watching. And then also, I think that's out of Alabama. And then there was a North Carolina case I know I've written about that I don't believe is yet scheduled unless that's changed since I've last checked the calendar. Yeah. So those two cases are kind of coming at it from different perspectives. So the redistricting case is more of what, like out of Alabama, is more of what you typically see. So they've every time you do redistricting, someone then sues and says, well, you're violating the law because these districts are based on race or something. And so that's what's coming up in the Alabama case, and the Supreme Court will have to determine
whether the redistricting was actually based on race, which of course would not be permitted under the Constitution, just like it's not permitted for, to discriminate in university admissions, et cetera. But the other question is, were they not looking at race, but they were looking at something else that also correlates with that? So, for example, it is okay to draw lines based on political affiliation. Well, we all know that also tends to follow race lines in certain ways. So the court has to be able to figure out, what were they really drawing the lines on? Are they just trying to improve their party's chances by including more members of their party in one district or another, or are they actually trying to do it by including members of one race in a district or another? So that'll be what the court's looking at there. The other North Carolina case, I think, is a little more interesting just because it's something the court hasn't looked at as often. This has to do with the elections clause. It's one of these pieces of the Constitution that you kind of no one focuses on when you're in civics class. But in the Constitution, it says that the entity that is in charge of governing how elections for your congressional representatives are done is the state legislature, that they have the authority to make the rules, like trying to figure out how and when you're going to have these elections and governing them. That's something that I think has been taken for granted, but there have been a lot of cases recently, and I think COVID shows us some examples where the state legislature might say, we're doing one thing, but then you have a state court that says, oh, no, we're doing a different thing. And that's really interesting because one of the options that the framers had was to say that the states get to decide how the elections are done. But that's what the original language said, the state gets to determine this. But then they changed it to the state legislature. So that says they didn't mean that the state broadly, which means maybe the governor, maybe the Supreme Court, maybe the legislature gets to make these rules. It's the state legislature. And while though they don't have complete free reign, they still can't violate the federal Constitution. The U.S. Congress can still write laws. The Constitution is very clear about this, that if they can override any state laws. So like the Voting Rights Act, for example, is an example where the U.S. Congress said, actually, we're going to decide how these elections are done in certain cases because we don't like how the states are doing it or because whatever. And so they can do that. But the North Carolina Supreme Court doesn't get to rewrite the law.
Right.
The North Carolina legislature.
So the idea would be that Congress would be more of the one that puts a check on state legislatures rather than the courts. Is that
right? And that's not something that applies in other areas. That's because there's a specific clause in the Constitution that says with respect to these congressional elections, the state legislatures do it. So it's not really a judgment call of, do we think Congress should do things, or states should do things? It's really just about, if the Constitution says, in this case, it's state legislatures that do it, you got to do what the Constitution says.
Right.
And so that's what's happening here. And we saw this during COVID, a lot of state Supreme Courts saying, hey, we want to give you extra days to turn these things in. We want to have voter ID or not. And that's one of the issues.
Right. Or like if a date was missing, I think that was Pennsylvania. Right.
Yeah, exactly. Date changes. And all of those are things that a state legislature could do, but not the state Supreme Court. They're not the ones to make those decisions, at least on the way the Constitution is written. So, but it's interesting because it's not a clause that the Supreme Court's had to deal with much. So they're kind of looking at it without the same background of as much precedent as you normally have. So it's a really good case for an originalist to look at because you're going, hey, now I can really dig in and say, what do these words mean? I don't have to worry about other people who've interpreted them wrong over the years. It's like, nope, we're just looking straight back to the text. And I think that'll be a lot of fun.
Well, and I was going to say, from a reporter's perspective, I remember covering all the lawsuits in the various swing states during 2020, and it was pretty chaotic. So I would think maybe something, a ruling here would help, I guess, make it less of a web that I'm trying to track with. Okay, so here's what's okay in this state and, not okay over here with I think it was in Pennsylvania, the Secretary of State going ahead and allowing extra days for mail-in ballots, that sort of thing.
Exactly. Yeah. Because you'll just have to deal with what the laws are. And of course those can change, but that's a lot less in flux than imagining, okay, the law says this, but then there was a case that went to this court that stayed this law and invented this new standard, and now the dates are this because a different state court said it. So in that sense, it also gives much more confidence to the people of the state of like, oh, we know and we can count on what our state laws are going to be. Because while, of course, the legislature can change it, that's just like not going to happen with the speed and the frequency that, all these various courts might be trying to rewrite things.
Mm-hmm. So, okay, we touched on religious liberty, elections, voting, and affirmative action. Is there anything else, before I ask you about, of course, the leak, the leaker that everyone's wanting to hear about? Is there any other case that I should be paying attention to, our readers should pay attention to, that you're tracking?
Those are the main ones. There's a fun one about an Andy Warhol piece that did it. Was transforming the work of another photographer, a picture of Prince, and he used that, and used kind of famous ways that he would recolor and rearrange photographs. And the question is, whose copyright is here? Is this a new piece of art? Do they owe royalties somehow for using this other piece of art in his work? And it's kind of a fun question, but I think most people, their lives don't turn on copyright law the same way they do some of the other issues. So that'll be another fun one to just watch.
Yeah. And of course, it's always interesting, the people I do. You'd be surprised. I do get questions about copyright. And especially when we had those, what was it, the band, the slants, that case that was before the court. Right. So it does come up once in a while. But okay, I do want to ask you, of course, we're talking a couple weeks before the term actually begins. So there could be news, an update on the investigation into who leaked that draft, abortion ruling. But my question to you is, say if we don't get some sort of update, do you think that having this unresolved could impact this term at all, like the working of this term? Is there like a cloud over the court?
I think unfortunately the length of time they've already taken to resolve it, and there's talk that Justice Gorsuch and Justice Kagan and the Chief Justice have alluded to some report coming from a committee that might tell what they've been doing and how the investigation's been going all along. I suspect if they knew who the leaker was, we wouldn't be waiting for some committee report, right? But I think just the very fact that we've gotten till now, it's September, the clerks from last term all left in July. So the most potent thing one could do, which is like fire the clerk that's in the process, is no longer on the table. Now, we don't know for sure it's a clerk. It could have been some other employee in the court. That would be interesting, because that means the leaker still could be at the court right now. And do we have other, opinions that are going to leak this term? Who knows? But I think it's already the fact that they weren't able to immediately and swiftly deal with the leaker is in of itself has already caused a lot of damage to the court, because people don't know who they can trust. I think it makes it a lot harder to work with your colleagues and for the clerks to work with clerks in other chambers. I think it just undermines the trust within the court and outside of the court. It used to be that every other institution in D.C. leaked like a sieve. You can get leaks from Congress or leaks from the White House, but you would never get
anything from the Supreme Court. Right.
Yeah, which makes it hard for people like you, right? You'd love to get leaks given you, I'm sure.
Exactly.
But that's not how it worked. People were really professional, and that is not the case, at least last term. I guess we'll find out this term. Is that something that, the institution is now changed and people will think it's okay because that person was not punished, that they can go and do this? Or is that hopefully, can we tamp that down and get back somehow to the normal just collegial working situation that the Supreme Court has been able to forge despite, the differences across ideological lines. So I think that remains to be seen a little bit. But I'm concerned because it's obviously led to a lot of real pressure on justices and intimidation campaigns at their houses that really continue to this day. There are still people every day of the week, except for Sundays, I think, in front of a different Supreme Court justice's house, trying to harass them and their families. And that's something that I think we can lay at the feet, at least in the instigation of it, as of the person who started that leak.
And your former boss, Justice Thomas, mentioned, I think it was in a talk earlier this summer, about the feeling, the like looking over your shoulder at the court, like a loss of trust, like you mentioned. And so I wanted to ask you specifically a few questions just about him for our readers and our listeners who, because you have the insight, just it's always fun to hear about. One is a obvious observation is he was kind of known to be quiet during oral arguments and not ask questions. But in recent, terms, we've heard more and more from him during oral arguments. What do you make of that, and why do you think that that's changed? Is that the new norm?
Well, I'm pleased to say I think it is the new norm based on what we've seen through the last term. The real change came in 2020 when the court was not hearing arguments in person, but was hearing them over the phone, and so therefore was kind of forced into a situation where they took turns. And for those who have listened to oral arguments, I know you obviously have. It's this crazy situation where there's people interrupting each other and they're interrupting each other's questions sometimes, and you have to try to get your answer in real fast before someone else asks you a question. And Justice Thomas's position was always, this is kind of rude and disrespectful to the attorneys. Like we're trying to talk to each other basically over them. And
right.
When you have the questions that aren't really a question, you're really like
sometimes when it feels kind of like the justices are arguing back and forth. I will say.
Yeah. So he was so frustrated with that was when he talked about it, he was always like, this is I don't want to add to the cacophony here. This is not what I want to see. And during COVID, it was a much more civilized process. It was like, hey, we'll take turns and you do your question, then I'll take turns, do my question. And so he was asking questions for the first time. And I think his colleagues recognized the value that added, because what we saw after they did go back into in-person is they've had a different system where it's kind of this unwritten rule where Justice Thomas gets to ask the first question out of the bat. So he doesn't have to interrupt someone or, be rude in any way. And they also offer an opportunity at the end. So the justices will do kind of free-for-all questions. And then they've been offering an opportunity at the end where the Chief Justice goes down in seniority order and says, Justice Thomas, do you have any further questions? Justice Alito, do you have any further questions? He'll just go down the line so that everyone you definitely have a chance to ask your question, and you do so in sort of an orderly fashion. I think Justice Thomas likes that, and I really think that I'm glad to see the court shift. It's a indication of the respect that they have for their colleague, I think, and I think it's made the court arguments a better process as well.
Yeah, and other than questioning, what about, over the years, the decades that he's been on the court, has there been any other changes you noticed in him, maybe his writing, his style, or even anything that you think Justice Thomas in 2007 would be surprised now looking at Justice Thomas 2022?
I think the biggest thing that, the Justice Thomas of 1991, when he was first in the court, would be surprised at is to see that he's writing in the majority.
Right. Well, that is very true. But he's still writing.
Yeah. Well, he's always been one to kind of identify problems that maybe the court hasn't grappled with or issues that need to be brought up. And then it's taken decades, because he's been on the court for over 30 years now, but that the court has ultimately been like, oh, hey, yeah, maybe that is an issue we need to look at. And then slowly, you now see a majority of justices joining them. So in some sense, that's always been there, that he's been the one to say, let's go back all the way to basics. Like you're asking me, with the analogy he gives, is adding a car to a train. When you're adding another case following a whole line of cases before that, he's like, look, you want me to add another car to this long train. I don't even know where the train's going. Like, who's driving this train? So what we need to go is trace it back, go forward one car at a time until we get to the very beginning. We find out what's going on. Where's this train going? Who's driving it? And sometimes, as you said, you'll find there's like a chimpanzee driving the train. You're like, whoa, we should not be adding more cases to this line of reasoning. So he's always really done that kind of pattern of looking at a line of cases and saying, actually, this is founded on some really misunderstandings. Let's rethink this, and then we can get this going on a straighter path. And I think just now a lot of that's coming to fruition. But he really continues in that vein, and you're always seeing those types of kind of let's go back and re-examine an area of law. I think recently a lot of that is happening in the administrative law field, because you're seeing uses of the administrative state and the bureaucracy of government to do things that it never was designed to do, whether it was like with the eviction moratorium or the vaccine mandate, where the president was using the agencies or different statutory provisions to do things that they weren't designed to do. And now in the court has been pushing back on that. And I think Justice Thomas is someone who has identified the problems with letting the regulatory state get out of control and start running things by itself, rather than remembering that, maybe Congress is supposed to be the one making our laws. Maybe the Constitution has to be governing it, not not whatever this unelected bureaucrat came up with. And so I think that's another area that we may see more of this term, particularly with the student loan actions that the president is trying to take, which is another, you take a statute and do something very different with it than what people were thinking.
Yeah.
So
and
we'll see.
Well, and you mentioned that he's writing more in the majority. And so like some analysts have said that the current court is Thomas's court, right? Ideologically. Mm-hmm. And so, he's still, even when he's in the majority, he's still writing those concurrences. I think one, of course, is with like the Dobbs case, for example, when he signaled there might be other precedent that the court needs to look at. And so I'm questioning, some people say he's getting older, retirement. Does that signal to you that he feels like his job isn't done? He's not, that they're still. What do you make of it?
I don't. I mean, people were speculating about his retirement during the Trump era, and I'm like, he was like hitting his stride even during the Trump era. Obviously, he's not gonna. He's still hitting his stride here. I think as the real intellectual heavyweight and leader on this new originalist majority. No way. He's someone who, as long as he is continuing to work at his full capacity, and he really is. I think people feel like he is older than he is because he's been on the court for so long. He was 43 when he was confirmed to the Supreme Court. That's kind of insane. And really young. While he's served there for 30 years, he's really just a few years older than Justice Alito, who has served much less time. But I think this is part of the reason people are like, wait, he's got to retire soon. Well, on the Supreme Court, mid-70s is like, the new 40.
Exactly. That's true. I thought I'd ask you too, like my last question is, is there anything from your time clerking for him, like a funny story you want to share with us, or even if it's not related to something with Justice Thomas, any sort of tidbit you can share, like an insight into what it's like inside the court for many of us who don't get to go inside, or even now, I mean, it had limited access, and especially given COVID, and we still aren't really quite sure what the procedures are going to be for this upcoming term.
Yeah, it seems like hopefully we'll be able to go back to actually hearing cases at the court. And tickets are always free for anyone who wants to go. It's just that for the more interesting or high-profile cases, you have to wait in a line, which is sometimes camping out for a day or two to get in. So, or the shorter line, which means you get to listen to 3 minutes worth of an oral argument. So that's a cool way to get a taste of it. As well, if you don't have time to, seriously camp out. It was just the most amazing opportunity to get to work for Justice Thomas. One of the things I didn't expect, but that happened with regularity in his chambers, was that he would call us up and ask us to take someone on a tour of the court that he had just sort of met somewhere. There were often cases where, the kid that was his waiter at the restaurant, or, someone he met on an airplane flight or something, that he got talking to them. And in particular, he has a real heart for people who are maybe like the first in their family to go to college, or don't have people who can be those mentors in their life, because that was his experience. I mean, his grandfather who raised him was barely literate. And when he was trying to navigate this, the opportunities that he had then to, go to college and then go to law school, and then like, he didn't have people in his life who knew these areas, who could give him good advice for how to go about things. And so he would often people into chambers, and I'm sure I don't know if they believed it when he'd say, hey, here's my card, call my secretary and come by the chambers. But he would sit with them for, sometimes an hour or so, and give them advice and help give them ideas for their own careers and education. And I just thought that was such a neat thing to see, that it never occurred to me a Supreme Court justice would go out of his way to do.
Or be that personable, right?
Yeah. And that just that selfless of like, here's someone who, is important enough that a lot of much fancier people might have trouble getting a slot on his schedule. But he was very generous with his time and trying to help people who he felt like had a lot of potential, but really didn't have the resources to take advantage of it.
Well, thank you. Thank you so much for joining me for the first episode and sharing all of your expertise about the cases coming up. And then, of course, your personal experience with Justice Thomas. We really appreciate it. And I'll have to have you back to break down what you thought of the arguments. I'm really interested to hear what you think on the affirmative action ones, how far you think the justices will go.
Yeah. Well, after we hear all arguments, we'll probably have a better idea. Right?
Exactly. Thank you so much, Carrie.
Thanks, Alex.
Thanks for tuning in to the first episode of Court Watch. I'll have another episode for you next month where we'll break down how the justices were leaning during arguments in the election-related case involving voting laws in Alabama. We'll also preview the big affirmative action cases coming up on October 31st. Thanks for listening, and I look forward to hearing from you all soon. Listen to my podcast, Court Watch, at WashingtonTimes.com or wherever you get your favorite podcasts.